is a key actor in the peace negotiations, there is nothing to suggest that those women would not have a significant impetus in those peace negotiations. Your Excellencies, I note that my time is due to expire in 1 minute. May I have a small extension of time to briefly address my final submission in relation to non-governmental organisations?
Yes, you do have a minute extra, but do use it well because you won't have another extension.
Thank you, Your Excellency. Secondly, Your Excellencies, Koptistan was not required to include the organisation of WAV in the peace negotiations under Article 25A of the ICCPR and Article 7 of CEDAW because there is no particular obligation to include NGOs by default. And in support of our submission, we point to the Human Rights Committee case of Marshall v Canada, in which there was a constitutional conference conducted in Canada which concerned the Aboriginal people of Canada, including the Mi'kmaq tribe. However, the Mi'kmaq tribe were not invited to that conference, and they took issue to that and brought a case before the Human Rights Committee. However, the Human Rights Committee found in that particular case that Article 25A of the ICCPR cannot be understood as meaning that any directly affected group, large or small, has the unconditional right to choose the modalities of participation in the conduct of public affairs. And similarly, Your Excellencies, we submit that WAV had no such right to participate in the peace negotiations. If Your Excellencies have no further questions, that concludes my submissions.
Thank you so much, Ms. Taneja.
President, may I ask for your indulgence? In order to make my mind on this, on the current case, I still need to be enlightened on two issues pertaining to submission number 4. May I?
Yes, yes, indeed.
Thank you, Mr. President. As you know, rights are not absolute. They can be limited. I'm talking now about the main instrument that you have mentioned, the International Covenant on Civil and Political Rights. Rights are not absolute. They can be, firstly, limited by clawback clauses, but they can also be derogated. And I was wondering why your government never used the faculty provided for by Article 4 of the Covenant following the outbreak of the internal conflict in 2006. Why did your government never use the derogation power that it could have used? This is my first question. And the second question is related to the limitations. Limitations, as you know, they have to be provided by law. They also have to be legitimate. But the last condition, and the very important condition, is the proportionality. To what extent the use of force by the police was proportionate to meet the purpose of the limitation to the right to life.
Thank you for your question, Your Excellency. In relation to your first question under Article 4 of the ICCPR, Your Excellency, we do not have the relevant facts to be able to answer your question in relation to why the government did not, in fact, take that course of action. So unfortunately, Your Excellency, we cannot make further submission on that point. In relation to your second point about proportionality, it is our submission that it was proportional because it was not an arbitrary deprivation of life, and that there was a real threat to life perceived by the particular personnel who were dealing with the riots in the Mufastan camp and the Revolutionary Square. And Your Excellency, my co-counsel Sumir Dayal will deal with this issue in further detail in its merits claim 4.
Thank you. You may be seated, Ms. Taneja. Mr. Dial, when you're ready, you may proceed.
Thank you, Mr. President. May it please the court, my name is Sumer Dayal, and I will continue the respondent's submissions on the second, third, and fourth claims on the merits, which are that the government of Copistan is addressing its obligations in relation to sexual violence, that the government of Copistan is addressing its obligations in relation to socio-economic rights to the maximum extent possible given its economic constraints, and that there is currently insufficient evidence beyond reasonable doubt to establish there has been an arbitrary deprivation of life in the Mofastan camp and Revolutionary Square. To the second claim on the merits. Your Excellencies, as the applicant has identified, the government of Copistan does have obligations in relation to the investigation and the prosecution of sexual violence. However, the applicant has failed to identify that Copistan is currently in a post-conflict situation. And in post-conflict situations, international opinion has recognized that states must develop a comprehensive peace strategy that is unique to its circumstances. This is
Ms. Early, Mr. Dial, let me put my difficulty to you, and you might resolve it. Does international opinion require for transitional justice measures to, without more, excuse impunity and disallow judicial remedies?
Thank you, Mr. President. The answer is no. The international opinion does not allow judicial remedies to not be available, and it does not allow the exclusion, and as you stated, it does not allow impunity. It is our submission that what the government of Copistan is following is a sequencing strategy, and this is in line with what international opinion determines to be unique to a country's circumstances. Mr. President, Your Excellencies, I would, yes.
Sorry, to stop you again in the flow. When you say international opinion allows sequencing, where does this is a court of law. We want to know what the law is. Sequencing, if we're to deal with the political opinions that are out there, we talk about peace and justice going hand in hand. How does sequencing fit in with hand in hand, which implies a simultaneous aspect to it, that justice must never be marginalized for the sake of peace in order to be sustainable? But it is a court of law.
Thank you, Your Excellency. I would like to answer that question in two respects. Now, I notice your doubt over my use of the term international opinion, so I would like to respond to what my justification is in terms of where this strategy comes from. The justification comes from the opinions of the Office of the High Commissioner for Human Rights in their Rules on Truth Commissions in Principles B and C, by the United Nations Secretary General in their 2014 Guidance Note on Conflict-Related Sexual Violence, Principles 2 and 3, and the Security Council Resolution 2106 at Operative Paragraph 4. So this is the opinion that we're actually referring to in this context. Now, how does it allow sequencing? Well, Your Excellencies, it has been identified in terms of truth and reconciliation processes in other countries that prosecution, immediate prosecutions, is not necessarily the best course of action. Now, for example, in the Sierra Leone Truth and Reconciliation Commission, in their final report at Volume 3B, Paragraph 215, stated that resting truth and reconciliation and peace solely on prosecutions is a risky endeavor. So then what is the answer that we have here? The answer is that we must take into account what the context of the state is, what the political environment of the state is, and create a peace and reconciliation strategy accordingly. What is the context of Copistan? We have an unstable political and economic environment. We have a peace agreement, as outlined in paragraph 28 of the facts, with WMD who threatened to renege on this agreement should prosecutions be initiated. At this point in time, initiating prosecutions is a risky endeavor. It could lead to the armed hostilities beginning once again if WMD reneges on the agreement. At this point in time, and I would like to know...
Let me stop you there. I mean, I thought there was a prosecution and indeed executions. Why wasn't that seen as a risk in terms of sexual violence against young women and their teacher?
Your Excellency, I believe you're referring to paragraph 33 of the facts in relation to the prosecution and execution of the perpetrators of sexual violence against West Act girls. Your Excellency, that is a separate context in relation to the fact that these were visitors from West Act, and it was in relation to the sexual violence that was perpetrated against them. It was not in relation to the internal conflict that Kopistan underwent, and it's not in relation to the perpetrators in question who would be coming from WMD and WMD's followers. Now, Your Excellencies, in order to support our assertion of a sequencing strategy, we would like to use the example of Chile. Now, for example, Chile had an initial Truth and Reconciliation Commission in 1990, which had a very limited mandate, similar to the KTRC in the current context. Now, when the political environment allowed it, in 2003, Chile instituted a commission of inquiry with a much broader mandate in order to investigate human rights violations, similar to paragraph 45 of the facts, which shows that Kopistan is initiating a commission of inquiry in less than a month. Your Excellencies, it is an unpalatable prospect that the prosecution for such grievous crimes is currently not being undertaken. However, in order to ensure that reparations are given to the victims in the context of peace and stability, we require delays in prosecution. And Kopistan has a strategy in order to first prioritize peace and reconciliation, second, engage in investigations, and then lead to prosecutions. Your Excellencies, if there are no further questions, I would like to turn to our third submission on the merits.
Well, you may. Your time is running out.
Thank you, Mr. President. And I would like to be brief in relation to the following two claims. In our third submission on the merits, the applicant has, of course, recognized that Kopistan has minimum core obligations. Now, it is not our submission that these obligations are being met. In fact, we can see quite clearly from the facts that the situation of refugees, IDPs, and in fact the citizens in Kopistan is dire. However, as President Moseneke has himself recognized during the applicant submissions, the government is undergoing economic sanctions. Resources are constrained. Now, the applicant identified general comment.
Well, be careful, judges only ask questions. They don't propose to provide answers at all.
Absolutely not, Mr. President. The answer, of course, is what I would wish to provide, and that is that in General Comment 3 of the Committee of Economic, Social, and Cultural Rights, at paragraph 10, they have stipulated that any assessment of minimum core socioeconomic rights must take into account resource constraints applying to the country concerned. Economic sanctions are having a detrimental impact upon the state of Kopistan. And the state of Kopistan's strategy to combat this is to prioritize peace and stability. The reason for this is, as paragraph 25 of the facts demonstrates, where Kopistan has shown to the world that it has a stable political environment, economic sanctions have been lifted. In order to gain access to further resources, we need to prioritize peace and stability, remove the economic sanctions, and then that will lead to an expansion in maximum available resources. Your Excellencies, in the interest of time, I would like to turn to our fourth claim on the merits.
President, just to follow up a little bit the question asked by my distinguished colleague, Justice O'Brien, the parties have, both applicant and respondent, have so far heavily relied on general comment of treaty bodies. I'm wondering what is the value that you are giving, legal value that you are giving to those general comments made by quasi-judicial bodies. Could you please elaborate on this?
Absolutely, Your Excellency. Now, the two sources of general comments that we have encountered in the proceedings currently are first from the from the Human Rights Committee, who have been empowered to provide expert opinions. So this is a subsidiary source of law, and they've been provided this power under Article 17, subsection, or rather, I withdraw that, Article 40, subsection 4 of the ICCPR. So these are expert opinions in the interpretation of the ICCPR. In relation to the Covenant on Economic, Social, and Cultural Rights, this power has been granted by ECOSOC Resolution 1985/17, and the committee is empowered to carry out the monitoring functions assigned to ECOSOC in Part 4 of the Covenant on Economic, Social, and Cultural Rights. The standing of both general comment sources is a subsidiary source and expert opinion on the scope of obligations. However, they are both authoritative in the interpretation of these conventions. Your Excellency, if there are no further questions, I will briefly make our submission of the fourth claim. And it is quite simple. The arbitrary deprivation of life can indeed occur. Excessive use of force can indeed happen in relation to demonstrations. However, our submissions are first, that there is insufficient evidence currently to establish beyond reasonable doubt that there has been an arbitrary deprivation of life, and second, Kopistan is engaging in an investigative process, as per paragraph 44 of the facts, to establish exactly what occurred in these demonstrations and then bring prosecutions. Now, Your Excellencies, the liability of the state is not absolute the moment death occurs. It has to be beyond reasonable doubt. This is recognized by the European Court of Human Rights in the case of Giuliani and Gaggio at paragraph 181, and also by the Human Rights Committee in the case of Suarez de Guerrero v. Colombia at paragraph 13.2. Now, yes.
Just very, but isn't it for the court to determine whether the evidence has been established beyond a reasonable doubt? That for the state to determine at the initial stages that it's not going to carry out proper investigations because it has concluded that there isn't sufficient evidence beyond a reasonable doubt is a complete conflict with the accepted jurisprudence in this area.
Your Excellency, thank you, and I agree with your submission. It is in conflict, but paragraph 44 of the facts does not state that the state of Kopistan is not engaging in investigations. In fact, it is. The state of Kopistan is therefore gathering the evidence in order to be able to establish whether this has, whether the threshold of beyond reasonable doubt has actually occurred. Now,
Thought you said that this was not going to move further forward because of the absence of evidence beyond reasonable doubt.
Indeed, Your Excellency, at this point in time, it cannot move forward. Now, the investigations have commenced within 6 months of the actual incidents occurring. And at this point in time, there is insufficient evidence. The state needs to be given the time to conduct a full investigative process. Only then can we talk about violations and arbitrary deprivation. Now, in Mofustan camp, non-lethal weapons were used, but non-lethal weapons and death occurring from it have to be analyzed in light of the context and the characteristics of the weapon that was used. And this is determined by Special Rapporteur Christoph Haynes in his 2014 report at page 17. Similarly, there could possibly be an imminent threat to life in the use of lethal force in the Revolutionary Square, as identified by President Moseneke as well, in that the president of the state, his car was actually in jeopardy, so there could have been an imminent threat to life. Is the state saying that yes or no? That's not our submission. We're saying that we need to conduct full investigations, and that is in line with the state's duty under the right to life in Article 6, subsection 1 of the ICCPR and Article 3 of the Neosho Convention. Your Excellencies, I would like to conclude with a final note. It is not our submission that the state does not have serious obligations towards human rights, but it is our submission that the government of Kopistan understands its people, understands its context, and has the plans and the mechanisms in order to fulfill these obligations. The applicant's claims should be dismissed by this court, and if not dismissed, the state should not be found in violation. May it please the court, if there are no further questions, that concludes the respondent's submissions.
Mr. Dial, thank you so much. And you may be seated. Thank you. we have come to the point of the right of rebuttal, and it will last for only 5 minutes. The applicants are therefore invited to rebut for no more than 5 minutes.
Thank you, Your Excellencies. The applicant would now like to reply to the submissions of the respondent. As regards the question of admissibility, Your Excellencies would like to maintain that the exhaustion of local remedies rule is one that is golden and one that is not cast in stone, as was espoused by the European Court of Human Rights in the Rigesen versus Australia case. And for this reason, Your Excellencies, we implore this court not to bind the applicant to the domestic remedies in Kopjestan. Furthermore, in Ireland versus the UK, the court stated that where there is an administrative acts that are repetitive and illustrate analogous breaches of international law, then the applicant would still not be bound to exhaust local remedies. And in this case, we'd like to point out that this court has actually issued 563 judgments against the state of Kopjestan regarding the right to life, the right to non-discrimination, and the rights of women. Therefore, Your Excellencies, we ask that this court permit that the merits of the case are admissible. As regards the merits of the first claim, we would like to point out that the non-inclusion of women in the peace negotiations was inconsistent with Kopjestan's international obligations, maintaining the fact that there is a state of non-discrimination, despite the fact that the women against violence were excluded from the peace negotiations, even after the ratification of the peace, even after the drawing of the peace agreement between the WMD and the government of Kopjestan. The government actually continued to exclude women against violence from political processes, as is stipulated in paragraph 45 of the Statement of Facts. As regards merits claim 2, Your Excellencies, we would like to point out that the elements of peace and justice insist, Your Excellencies, that a state has an obligation to ensure that the human rights violations do not recur. And in this case, Your Excellencies, despite the government policy to temporarily stop the prosecution of violations, the facts illustrate that gender-based violence in Kopjestan is increasing. And for this reason, we are asking this court to consider the facts, and the prevalence of gender-based violence in the state of Kopjestan. Further, we'd like to point out that transitional justice processes in South Africa and in Kenya insist that failure to prosecute should be conducted in a reasonable manner. The facts of the case point out that the state is taking a prejudicial or discriminatory position when it comes to prosecution. The prosecution of Wastak High School girls took place in about 6 days, and this is probably because of a close relationship between the president of Wastak and the president of Kopjestan, as the girls were close relations to the president of Wastak, Your Excellencies. Further, the respondent
really saying in that instance there was no prior investigation and delay, and therefore delay cannot now be a valid defense, or desire to investigate cannot be a valid defense.
Indeed, Your Excellencies, and the fact that the application of the transitional justice argument is discriminatory. Your Excellencies, the respondent has further relied on general comment number 3 on the obligation of states to social economic rights. However, we'd like to point out that the general comment 3 states that as a matter of priority, states must provide basic essentials to individuals in the state. And in this case, Your Excellencies, the government of Kopjestan has an obligation to ensure that these essentials are provided. The United Nations High Commissioner for Refugees in the temporary guidelines states that despite economic sanctions or monetary constraints, a government still is obliged, while seeking international cooperation, to ensure that essential provisions are guaranteed, and secondly, that it does not take retrogressive measures. Therefore, the position of the government in this case is unmerited. And finally, as regards the merits of the last issue, we'd like to point out to this court that the government of Koptistan itself has stated and accepted that its position as regards the use of force in the Mufalstan riot was unfounded, stating that it had not adequately trained its junior officers to use force. The Inter-American Court of Human Rights in the case of Corazzo versus Venezuela has pointed out that a government must train its officials to use force under international standards. And for these reasons, we maintain our position as the applicants, and we rest our case. Thank you, Your Excellencies.
Yes, it is time to rest your case, indeed. Time has run out. At this stage, the court will adjourn to deliberate, and you will be informed of the outcomes and evaluations in due course. Court will rise.
Thank you very much, ladies and gentlemen. Please take your seats. Is 2-2 here? Do you know where that is? So the original plan is that we would have a tea break now downstairs, but we are running slightly behind time. And so the judges' deliberation will be much quicker than we had originally thought. And this is because the High Commissioner will be joining us for the next part of the program. And he is due to arrive in the next minute or so. So we expect that the judges and he will come back into the hall within 10 minutes or 15 minutes or so. And so it's probably not a wise idea for us to disperse and go far. So if it's okay with you, we can maybe just hold our seats for another 10 or 15 minutes, and then we can quickly go into the next part of the program, which will involve the judges giving some feedback to the finalists, but in a general way, I think, to all of us, because the finalists are, I think, a microcosm of the wider group of participants. So they will share some thoughts and some advice maybe, and so forth. And then we will hear from the High Commissioner, and there will be one or two other speeches, and then we'll be done. So thank you very much for your patience. rise, all rise. Please be seated. Thank you. High Commissioner, Your Excellencies, ladies and gentlemen, and dear World Moot participants, welcome to nearly the end of the Moot, at least I think for today, the greatest show in the world. What an honor, what symbolism to be in this spectacular venue, where countries of the world come together in an attempt to move human civilization, in the words of the African Moot competition, forward from human wrongs to human rights. Today we think, we hope, we dare to think that we make a modest contribution to these noble efforts. Ladies and gentlemen, the proceedings will continue as follows. The judges in the final round will be invited to make feedback to the students, and as I mentioned earlier, I think for those who were not in the final, I think please take these words to heart as well. And then Justice Moseneke will say a few additional words at the end in connection with the renaming of the Moot competition this year. Thank you.
I have been asked by Honourable Commissioner and colleagues, I've been asked by fellow judges to make the initial remarks about the Moot competition in the final round this morning. Let me start off by saying congratulations. I guess I'm getting a little old. I just get amazed at how bright you people are. You are incredibly intelligent. I never cease to be amazed by the excellent grasp of international law, both in process and substance that you displayed. And I thought that the questions, and we had a bit of a debate before we started with other judges, we asked them many or few questions, and we tried to strike a balance of sorts in fear that we might derail you. It didn't happen. Every time we threw questions at you, and I hope they were thoughtful questions and got you to the issues, we tried to steer away from the facts and get you to normative debates. What is the law? Has it been upheld or breached? And should therefore be remedies? And I just want to congratulate you very briefly and say, I found you truly not wanting. And on my scorecard, the differences are marginal. So this was a very close finish. I think it's a photo finish in my book, but I'm one of 5 judges. But I just wanted to say once more, very well done. And I wish you well in your careers. May you take this on forward and move us from the dark spaces of human civilization to well-lit spaces where we can observe human decency even beyond the present. Thanks.
Thank you. I just wanted to say how amazed I am that anybody managed to read that problem and work out that problem, because I spent several days retyping that problem, reorganizing the problem, and noticing that the problem had no page numbers on each page. So all I can say is you're much better. I wouldn't even be able to work out who was who and who got lost along the way. There were so many characters. Fabulous, really. I really, really enjoyed it. You've come so far, done so well, and it makes me just really, really hopeful for the next human rights officers. Thank you.
Well, this was such a privilege and an honor from my perspective. As Jane has said, this story that you were faced with was quite a tome. I can't say that as I was plowing my way through, that I was excited at the prospect of a denouement, but I was wondering, was it ever going to arrive? So I'm really, really impressed with the ability of the four of you to have absorbed the facts so deeply. And if I may just take a personal moment and say, from my practice as a barrister for 10 years, I remembered, while I was listening to you, learning as I went along the importance of absorbing the facts and working with the facts and really being on top of the facts. Because if you were able to do that, it puts you one step ahead of your colleagues who may, in certain circumstances, have simply been focusing on the law. So, of course, it's a combination of both. And I found today that all of you were able to prove to us that you were completely on top of this brief and it wasn't something that had been prepared at the last moment. If I may take the opportunity to just give you a little bit of something both from my practice and from my observations now. I have never been a judge. I don't anticipate ever being a judge. I don't have any particular desire to be a judge, but I will say something from the perspective of up here that I noticed in my few moments here. That showing respect for the bench is hugely important, and all of you did this very, very well. As you progress, if any of you remain within the law as a practice, as advocates, always try to ensure that that is there while not at the same time compromising and ending up being sycophantic. You really want to retain your own characters while you're presenting your cases to a court, and be respectful, but be yourselves, and don't compromise that. It's something that I would hand on to you, because a judge really gets too much of that. Sorry, judges, if I'm undermining the potential for delightful sycophancy, but it is something that I wanted to pass on. So overall, you did a fantastic job. I was very impressed, and I'm sure all of you who have been involved in this competition must have been excellent for this to have emerged from the last results, and your contributions to human rights is really important, and we hope that you will, all of you, contribute into the future in this tremendously important field. Thank you.
I will gladly add my congratulations to those of my colleagues and add perhaps 3 more specific comments, being a judge for 20 years but also a professor for 30. 3 specific comments. The first is that I appreciate when the cases which are discussed are really discussed with the facts on which these cases were based, because it helps us understand your rationale, your argument, etc. Some of you have done it quite well. I will not naturally personalize. The second point underlines what Justice O'Brien just said. Listen really to the questions and don't answer too quickly. Here you were very short of time, but generally just listen, and if you take 20 or 30 seconds in order to present an articulate answer, just take this time. It's also something we understand. And the third point is a general observation. I was very impressed by you, impressed by the tension, especially in one pleading, between a political forum and a legal court. And naturally this tension, especially in international law, international tribunals, is very present. I have some experience on it, and I found it very interesting to feel this tension in the pleadings in general, and in one pleading in particular. It's something you will have to live with if you become a judge or a practitioner in international justice. And under this respect, this moot court was very, very instructive to me. Thank you.
Thank you. I'm mostly covered by my distinguished colleagues. First, I would like to beg your understanding. I would have liked to speak in the Coptian language, but I don't master it, as I just said before. The second thing is that I'm not as smart as you are, so I would have to read in my badly written notes in order to make my comments. One word, I would say one word, excellent. I found the pleadings excellent. Coming back now to the reading of the case, it was the most painstaking exercise, I would say. I'm used to read difficult cases in my capacity as a judge of the African Court or former capacity as secretary of the ICJ. We have difficult cases, but this one I would say was a very difficult one to read. But again, I would say that I was rewarded by the pleasure of listening to the four teams in their pleadings. Concerning the memorials, I think they could have been written in a more concise way, within the maximum length of 3,000 words, as it is required by the rules. Concerning the pleadings now, I personally and my colleagues as well tried to destabilize the teams, but with no success, as I can assess it myself. You have a good knowledge of the facts, good knowledge of international law, of the procedures. I would say that when pleadings, and again I'm drawing from my own experience, when pleadings are well articulated, when pleaders are good, this eases the work of the bench. This eases the work of the bench. What I would say in conclusion is to invite the four teams to maybe visit the website of the African Court. We have a list of, actually we have a legal assistance scheme and we have a list of lawyers. And I would kindly invite you to register on this list of lawyers. And personally, I will be very glad to be meeting you in the future, pleading before the African Court on Human and People's Rights. And there's no requirement of citizenship in order to be listed on this list. But as I said, all the teams were equal, but I don't want to prejudge the the end result of this moot court competition. But as you know, that even at the World Cup football, there's always a winner. And even though it's always difficult to assess who is the best, sometimes it's difficult to lose, and especially when it reaches the penalty shot. And I think in this case it will be almost the same. So I don't think that the losing team should be sad, whatever the losing team is. I have a particular question to ask actually to